Hi, everyone. I'm responding to a review of the McCoy's preliminary objections and had a few pretty cool questions, so I thought I'd try and address them. Althea asks if dismissed with prejudice is the same thing as double jeopardy. I had never thought of it that way, but I guess you could say it's the civil counterpart to double jeopardy. Double jeopardy, in my knowledge, is only a criminal concept, and dismissed with prejudice, I've heard it used in criminal cases, but I think generally civil. So, yeah, I think it is, Althea, and I'd never thought of it that way. Rick asked if you can request attorney's fees if the opposing party engages in frivolous or baseless complaints. And yes, that can be done both in federal court and in state court. And interestingly enough, next week we'll read a chapter on the experience of the plaintiffs in the case involving a civil action. So you'll see that, yes, you can do that. In fact, if you'll forgive me, I'm going to abbreviate my answer because I think we'll recover this again next week. Liz asked if the misstatement of the location, that is incorrectly listed to be in Manayunk when they're actually an old city, would it have any effect on the case? It would not in this particular case because both of the locations are within Philadelphia County. If one were outside the county, that might be a difference. And if it were outside the state and we were in federal court, it could make a very big difference. So, good question there. Moses asked if a preliminary objection will erase or suspend certain counts from the court record during litigation. Let me answer a couple things. First of all, if we receive a complaint and we file a preliminary objection to that complaint, we will, if the complaint is overruled by the judge and essentially thrown out, we will have to answer and we'll still have our 20 days. So it's not technically suspended, but your duty to answer is suspended while the preliminary objections are pending. Now, if your preliminary objection to count one, as in, let's say, the McCoy case, would be that civil conspiracy is not a valid claim or they didn't plead it properly and prove it, and the court dismissed it, then it would remove that from their complaint. So you'd know you didn't have to deal with that any longer. Going to Lisa's question about if an objection's overruled, does that mean a claim is dismissed? No, I think you have them. It's a little tricky. And two things. Let's be more technical. If it's an objection, that happens in court when lawyers stand up and object. A preliminary objection is a pleading that we've spent a week on. So I'll answer the question that you wrote, and I'll answer the question that I think you might have meant. Objection is overruled. That means your objection's no good. So the witness would be allowed to answer. All right. If an objection in court would be sustained, in other words, they ask a witness a question, I object, and I say it's beyond the expertise of the witness. Say they were an expert witness in biology and someone asked them a question about baseball, that would be beyond the scope of their expertise, and the court probably wouldn't let them answer it. Now, with preliminary objections, if a preliminary objection is overruled, think about it. We get the complaint, I file a preliminary objection. If it's overruled, the claim is still good and I have to respond now, but I get 20 more days. Let me say that again. If I receive the complaint as a defendant, I decide to file a preliminary objection. If the preliminary objection is sustained, they'll throw that part of the complaint out. If it's overruled, if the objection is overruled, preliminary objection is overruled, then I'm going to have to get 20 more days to answer to that. I'll have to file an answer at that point. So I hope that clears that up, Lisa. And thanks for your questions, everybody. Talk to you soon.